Hi, I'm Aaron Thomas with prenups.com, and this week I'm answering the question, how can a prenup be thrown out? So first, you should know that prenups are by and large enforceable. We just did another video on that if you want to check it out. They wouldn't be very good contracts if you could just decide you didn't like it and have it thrown out, right? It's kind of like if you sign a purchase agreement to buy a house, you've got to pay the mortgage. You can't just ask for it to be thrown out unless there was something seriously wrong with it in the first place. Same thing goes for a prenup. It's a contract like any other contract, but there are things that could be deficient with the agreement. And yes, a judge might throw it out. The number one reason a prenup is not going to be enforced is when people try to do them on their own. Each state has different rules around what a prenup requires to be legally enforceable, and they're not always intuitive things that a layperson is going to think of off the top of their head. Some states require very specific waivers. Some states require witnesses in addition to a notary public signing off on the document. If you haven't followed the state required rules for enforceable prenups, then you don't have an enforceable contract. So that's just part one. Don't write your own prenup. Get a lawyer that knows what they're doing. Beyond that, there are generally three things that can get your prenup thrown out. Again, these can vary state by state, but these are the general rules. Number one, there has to be a disclosure of assets and debts, and often income as well. Why? Because you're trading the state's default prenup for your own custom prenup. You're trading one thing for another. And to make that trade knowingly and intelligently, you've got to know what you're giving up. That means knowing what assets and debts are on the table. Many states don't actually require that you write down your assets and debts and show them to each other. But if you don't do that, how do you prove that you disclose your finances to your spouse if they try to get the prenup thrown out later? So a good attorney is going to require that you not only write down a schedule of your assets and debts, but they're going to attach those schedules to the prenup itself so that there is no question that those disclosures have taken place. If you hid assets or debts when you signed your prenup, then you may have trouble enforcing it later. You won't be able to have the prenup thrown out if you're the spouse at fault, but your spouse may be able to have it thrown out. So non-disclosure of assets is one way that a prenup can be thrown out. Second way a prenup gets thrown out is if it wasn't signed voluntarily. And this goes for pretty much every contract, really. I mean, if you hold a gun to someone's head and force them to sign a contract, a court is not going to uphold that contract. You probably don't need a lawyer to tell you that. But in the context of a prenup, voluntary may have a different meaning. Most states are going to require that you have had the opportunity to have met with a lawyer and gotten advice before signing the agreement for it to be enforceable. In some states, that just means that you had a day or two to meet with a lawyer before your wedding date. In other states, they may have a specific amount of time, like a week or 30 days prior to the marriage, that you have to be given prior to the date of the marriage. In some states, they may require that both spouses have attorneys, full stop. If you watch some of my other videos, you may already know how I feel about this. Don't ever spring a prenup on your fiance last minute for the wedding. It's a horrible way to start your marriage. It destroys trust. It's not fair. Don't be that person. That said, someone saying, I'm not getting married unless you sign this prenup, that doesn't count as forcing you to sign the prenup. If someone says, I'm not getting married unless you sign this, and you don't want to sign it, then you shouldn't sign it. Last way a prenup can be thrown out is if it's found to be unconscionable. What does unconscionable mean? In layperson speak, it means that it is so fundamentally unfair that a court can refuse to enforce it. Now, I should point out that there is a huge difference between unfair and unconscionable. Just because one person is left a multimillionaire and the other spouse isn't, doesn't mean that the prenup is unconscionable. It's got to go a huge step beyond just unfair or an unequal division of assets. If one person is left a multimillionaire and the other spouse is left on public assistance, for example, then yes, that might be seen as unconscionable, but it's really going to come down to the opinion of the judge. I will warn you that I've seen many prenups that we would all view as unfair be upheld. The court isn't going to throw something out just because you agreed to a bad deal. It's got to be well beyond unfair to be thrown out. Like I said, if your prenuptial agreement is prepared correctly, then it is going to be rare that a judge is going to throw it out. It is like any other contract. If you want to know if the prenup you signed is enforceable, come visit us at prenups.com and set up a consultation.